Hello. Thank you for those watching live and later. Today we are going to talk about bankruptcy during a divorce in Georgia. I'm Raluca. I provide legal services in the area of family law, immigration, and estate planning, and I'm here with my marketing and officer manager, Nina Clear. And we really appreciate your support. Every time you like, comment, and share helps others see my videos. So I appreciate it.
So first tell us, why is it important to talk about bankruptcy during a divorce in Georgia?
Both divorce and bankruptcy deal with assets and debts. So if you are contemplating bankruptcy, you shouldn't ignore how they can impact each other. Georgia is an equitable distribution state, which we'll explore more on Thursday. This is what governs property distribution as well as debts during a divorce. Bankruptcy may impact property distribution and payments of debts. I've had people ask about this, as many marriages, unfortunately, end because of financial issues, and clients who wanted me to handle both in the past. So I wanted to address these issues.
And is bankruptcy law governed by the laws of Georgia, like the divorce laws are?
No, like immigration, bankruptcy law is governed by the federal statute. Federal law typically takes precedence over state law, and in this case, over the divorce.
So are you able to handle both for your clients, the bankruptcy and the divorce?
I could, but I did not, and I do not. As attorneys, we should avoid conflict of interest. This means that we should not represent two people who may have different interests. While you can have a couple sign an agreement that they are okay with this conflict, I didn't feel comfortable doing it. And plus, each is a separate and distinct area of law. I do have experience in both, but again, I want to avoid any appearance of impropriety.
So if you had a client whose divorce you were handling, would you file their bankruptcy for them?
If I was representing one client in a divorce, I could file their individual bankruptcy. I had a case that was reversed in that I initially was hired by the couple to file for a joint bankruptcy, and then during the bankruptcy they decided to divorce, so I couldn't handle that. I basically didn't handle any of it anymore because they already had conflicting interests.
So you got out of both the divorce and the bankruptcy.
Yes.
Then? Okay. So there are different types of bankruptcy, right?
Yes, Chapter 13 and Chapter 7.
And does a divorce dictate or impact which one you can file?
No, not really. If you decide to file jointly, which can be advantageous for both parties, you should file for the bankruptcy first, which will delay filing for divorce. Chapter 7 can be filed before or during the divorce, and usually it takes about 6 months to process. Which one you file depends more on if you're filing as a couple or an individual, and also the income amounts.
And how does your income impact that?
Well, very briefly, you must determine if you make more than the median state income based on your household size. If you do, you cannot file for Chapter 7.
Does filing for bankruptcy impact the divorce proceedings?
It can. Typically, a bankruptcy court will put an automatic stay on all court proceedings, and if you're in a court getting a divorce, the proceedings may be stayed.
And a stay, do you want to tell us what a stay is?
Sure. It means that you cannot move on with the case that you already have open in the court. So in this case, the divorce is going to wait for the bankruptcy to finish before it moves on.
And could you ask for that to be changed in a domestic issue?
You can, but you can only ask for a partial lift of that stay, so you can decide other issues like discovery, child custody, divorce and limited support matters, but not about the property distribution.
And when you say divorce,
And
you just
that's-
mean like dissolving the marriage, basically.
Pretty much,
Yeah.
yes.
Okay. So would most couples file a Chapter 13?
Possibly. It really depends on the factors that we discussed. It's less advisable for a couple who wants to divorce to file a Chapter 13 because it can take 3 to 5 years for to make the payments and to finalize it.
Which would slow down your divorce.
Yes.
So, or maybe it would be advisable because then you could resolve everything, right?
Well, it depends on each circumstance, the circumstance of each person, yes.
So you can file for bankruptcy before or during the divorce.
Yes, you can, but it's easier with the Chapter 7 filing. And keep in mind that the final order and decree of divorce may impact property and debts that you declare in your bankruptcy if you file individually.
Is there anything in regards to divorce that you cannot discharge in a bankruptcy?
Yes, you cannot discharge support payments in a bankruptcy. Plus, if you file bankruptcy after the divorce, you cannot discharge joint debts that are part of your final order unless you file for the Chapter 13 and it is part of your property division.
Okay, and support payments would be like alimony or child support, right?
That's right.
Okay. So what's your best recommendation for people who are contemplating both bankruptcy and divorce?
I would recommend that you speak with 2 attorneys, one who is qualified in a domestic or family law and one in bankruptcy. Thank you so much for watching today. Tomorrow we'll be talking about the fiancé visa again. And on Thursday, we will discuss the equitable distribution in a divorce. And I hope you appreciate the irony of our talking about divorce and property distribution and a fiancé visa in the same week. Thank you for watching. See you tomorrow.